All right. A very warm good evening to everyone here who is joining us for a webinar today. My name is Bhavna Tukkar and I am here representing SIUK team. First and foremost, thank you everyone who has joined us today, which is our session today, which is on intellectual property responses to COVID-19 with Queen's Mary University, London. And I also welcome Ms. Mishi Sadana, Ms. Jasprit Kaur, and Professor Duncan Matthews from QMUL. And I also welcome Ms. Soni, Ms. Monica, and Ms. Sushila for giving us this opportunity. They are from Manipal University, Jaipur, which is a top Indian university situated in Jaipur, Rajasthan. On this note, few of you may not be knowing that what SIUK is, perhaps what we do. So just a quick introduction on SIUK. So SIUK is a global organization with its presence spread across 25 countries. We are the official representatives of UK universities. We assist students across the globe to seek admission in top UK universities with our premium servicing for Oxford's Russell Group and non-Russell Group universities. In case you need extra information on our services, requesting everyone to visit our website, that is www.studying-uk.in. So on that note, I would like to hand over this session to Ms. Mishi Sadana. So Mishi, the floor is all yours.
Hi, hi everyone. Thank you, Bhavna. As a student recruitment advisor for Queen Mary, I'm thrilled to be hosting this stimulating session today and would like to welcome everyone. A very happy Eid and a happy Akshaya Tritiya to all celebrating in India, and a special mention to Manipal University, Jaipur for inviting Queen Mary University of London. I would like to begin introducing the key members for this session, followed by a taster lecture and a question and answer. So today we have Dr. Soni Kulshestra. She's the Associate Professor at Department of Law, Manipal University, Jaipur. Ms. Monica Punya, Assistant Professor, Department of Law, Jaipur. Mr. Hamid Garda, who's the Marketing Manager at CCLS Queen Mary. Ms. Jasprit Kaur, our Regional Advisor, South Asia for Queen Mary. And we also have our man of the hour, Professor Dr. Duncan Matthews, who is the Chair in Intellectual Property Law. He's also a director at Queen Mary Intellectual Property Research Institute. Dr. Matthews has held various prestigious positions in his career and has worked with some of the finest institutes. He has worked as a lecturer at Warwick and has worked as a researcher in think tanks like National Institute of Economics and Social Research, and is also a lobbyist for EU2. He's a member of the Chartered Institute of Patent Attorney Education Committee, and has worked in MIHR on an IP handbook for best practices. He is also a co-founder of European Intellectual Property Teachers Network. Now, the concept of intellectual property has evolved over the years, and we know that companies all across the world are diligent when it comes to identifying and protecting intellectual property because it holds such high value today and increasing knowledge-based economy. So without further ado, I would like to invite Professor Dr. Duncan to share his wisdom with us. Over to you, Dr. Duncan. Thank you.
Thank you, Mishi, for the kind introduction. So I will share my screen with you, and you're now able to see my slides. Well, first of all, let me say how happy I am to be speaking to you today, although sad that I cannot be with you in person. I have visited Rajasthan on many occasions, and the city of Jaipur is one that I hold very close to my heart, with wonderful people and a beautiful city. So I hope sometime soon I'll be able to return in person to visit Jaipur. So the topic of my talk today is really, of course, one which is very urgent and very current. And I will begin by showing you a tweet which came from the United States Trade Representative, Catherine Tai, on Wednesday of last week, on the 5th of May. This statement was significant because, as you will be aware, it marked a significant change in previous US policy. Because what the United States has said is that it will support waiving intellectual property where this is necessary to make available COVID-19 vaccines. So obviously the main type of intellectual property we're concerned with here is with patent rights. And as you will be aware, patent rights give the owner of the patent a period of time, usually 20 years, during which no one else can make, sell, or import or keep the product without the permission of the patent owner. So the Biden administration in the United States is essentially saying that countries which opted to set aside their IP rights for COVID vaccines during the pandemic would be able to do so without facing sanctions under international law. But you'll note from the tweet that the United States is not just proposing a waiver on patents. It's really a waiver on intellectual property. So that would cover other types of IP. Particularly, we are concerned here with undisclosed information, confidential information, by which I mean know-how and trade secrets, which are essential for the manufacture and storage of vaccines, particularly these newer mRNA vaccines, which need technical knowledge to manufacture them. Plus, this would also cover the data which is included when the IP owner applies for medicines authorization, proving that the product is safe and has passed clinical trials. So access to all these other types of IP, in addition to patents, is essential if we're going to really achieve a scaling up of vaccine manufacturing, particularly in low and middle income countries. And the second thing that the Biden administration announced in this tweet was that the United States was going to actively participate in text-based negotiations at the World Trade Organization. And in this respect, it's important to understand that actually this initiative was begun by India together with the government of South Africa. So on the 2nd of October 2020, a proposal was made to the World Trade Organization to have a waiver to set aside the enforcement of IP rights, not only for the vaccines, as was proposed by the US last week, but to have a much wider waiving of intellectual property rights to cover all types of technologies which could be relevant. So these could be therapeutic treatments for people suffering the symptoms of COVID-19. It could be IP for the diagnostic kits. It could be IP for the ventilators or for personal protective equipment. So the Biden administration proposal for a IP waiver made last week is much more narrower and less far-reaching than the proposals of India and South Africa. So having sort of set the current context, now let me take a step back and look at the big picture, and we'll return to some of these current debates at the end of my talk. Well, the context in which these discussions are taking place at the moment is, of course, the World Trade Organization, which the WTO agreements were signed in April 1994, and included as an annex to the WTO agreement, the trade-related aspects of intellectual property right agreement, what we call the TRIPS agreement. Now, the TRIPS agreement came into force the following year on the 1st of January 1995. And a small number of high-income economies, developed countries, were required to comply with TRIPS by the 1st of January 1996. Middle-income countries like India were required to comply with TRIPS later, by the 1st of January 2000. And for areas of inventions which were not previously patentable in India, there was a longer period until the 1st of January 2005. The reason that India had a longer period of transition until the 1st of January 2005 was that under Article 27, paragraph 1 of the TRIPS agreement, there is an obligation for all WTO member countries, including India, to make patents available in all fields of technology. Now, prior to the TRIPS agreement coming into force, the Indian Patents Act of 1970 contained in Section 5, subsection 1, a provision which provides that no patents would be granted in respect of food products or medicines or drugs, although a patent could be granted for a method or process of manufacture. So this is a well-known story which you will already be aware of, that this was essentially the provision first suggested by the Iyengar Committee in India, which led to the rise of the high-quality generic drug industry, with companies like Cipla, Dr. Reddy's, and Ranbaxy becoming the world manufacturing center for off-patent generic drugs. And roughly about 80% of the world's pharmaceutical sector is provided by these Indian companies. But for countries which don't have the same domestic manufacturing capacity as India, they faced a sort of a double problem. After the TRIPS agreement came fully into force, India had to start granting patents for pharmaceutical product inventions. This meant not only that the availability of medicines in India was subject to higher prices and the restrictions which we would expect by the exclusionary nature of patent rights, but it also meant that it limited the ability of the Indian manufacturing base in the pharmaceutical sector to export these low-cost but high-quality products to other countries in need. Now, the TRIPS agreement, in a way, predicted this problem and contains a number of inbuilt safeguards or so-called flexibilities. And these flexibilities include the use of compulsory licensing without the authorization of the patent holder, particularly in situations of a national emergency or other circumstances of extreme urgency. And I'm going to come on in a moment to talk about how compulsory licensing might be of assistance during the current COVID-19 pandemic. However, at the time, there was a problem in the TRIPS agreement. In Article 31F, the provision in TRIPS which talks about the granting of compulsory licensing, it specifies that a country that allows the manufacture of a product without the authorization of a right holder under this scenario, that such manufacturing should be predominantly for the supply of the domestic market of the WTO member authorizing such use. Now, for a small sub-Saharan Africa like Rwanda, it has no domestic manufacturing capacity. So it was deemed under the original version of the TRIPS agreement to create a barrier to access to medicines, because a country like Rwanda would not be able to manufacture for domestic supply and was therefore limited in the way that it could use this provision. In recognition of this problem, a process started with the DoHA Declaration of November 2001, whereby the DoHA Declaration at the ministerial meeting of the WTO that year reaffirmed the right of WTO members to use to the full the provisions of the TRIPS agreement, which provide these types of flexibilities and safeguards. And the DoHA Declaration went on to recognize in Article 6 that WTO members with insufficient or no manufacturing capacity in the pharmaceutical sector could face difficulties in making effective use of the compulsory licensing under the TRIPS agreement for the reasons that I've just explained. Now, this process, which was started with the DoHA Declaration in 2001, is very instructive when we start to consider the IP responses to the COVID-19 pandemic. Because I began my talk by explaining the different proposals from the US and from the India-South Africa proposal to waive IP rights. But at the moment, the so-called text-based negotiations, drafting the actual wording of such a waiver of IP in response to COVID-19, those text-based negotiations have not even yet commenced. So let's compare the proposed COVID waiver and the negotiations which will be forthcoming, with what happened 20 years ago, when of course the world was facing a different pandemic. By that I mean HIV/AIDS. So in response to the DoHA Declaration in November 2001, it took more than 18 months. It took a year and a half before a temporary waiver of this small technical problem that I just described, which was being faced by countries like Rwanda, who couldn't manufacture to deal with a national health emergency themselves, and wanted to ask manufacturing countries like India, Canada, and Brazil to manufacture for them under compulsory license for export, this so-called waiver of Article 31F. This simple problem took 1.5 years to resolve before the text was agreed for a temporary waiver of the TRIPS agreement at the WTO. And in fact, it was only in December 2005 that a protocol was agreed to make this temporary waiver on this compulsory licensing provision for export a permanent feature in the TRIPS agreement. And in fact, Rwanda, the country from my example, in July 2007 became the first country to notify the WTO members of their intention to use this system. And essentially what happened was that Rwanda asked Canada to manufacture HIV/AIDS drugs to be exported to Rwanda under that compulsory licensing system to deal with a national health emergency. However, making this temporary waiver of compulsory licensing permanent, in fact, didn't take place until the 23rd of January, 2017. So as we look at the picture of the former Director General of the WTO, Alvarez, with his delegates from some of the WTO member countries, we have to ask the problem, was the issue of access to medicines to deal with national health emergencies solved by this lengthy process of establishing a waiver simply for compulsory licensing? Well, now let me turn back to the COVID-19 pandemic. This is the dashboard from Johns Hopkins University in the United States, which of course shows the terrible extent of the deaths that the world is facing with the COVID-19 pandemic. And of course, it's just appalling to see India and also the United Kingdom towards the top of the list of countries, both for the number of cases and tragically for the number of deaths from COVID-19. So can the waiver of compulsory licensing, which was negotiated all those years ago, help in the IP response to the pandemic? Well, of course, the overriding public health objectives in the COVID-19 response are to test, to treat, and prevent the spread of the pandemic. And for this, public health strategy has focused on, of course, the diagnostic kits, whether these are the lateral flow antibody tests or the more sophisticated antigen tests and PCR tests. Of course, these are all protected by intellectual property rights, by patents, by design rights, etc. So this is why the India-South Africa proposal went further than the US current announcement and said, look, this is not just about vaccines, it's about the diagnostic kits to test and prevent the spread of the virus as well. Also, at the beginning of the pandemic, you will recall that there were attempts to repurpose a number of known pharmaceutical products, such as remdesivir, a drug which had already been patented in the United States and elsewhere for the treatment of Ebola, Kaletra, a drug also invented and patented worldwide by an American pharma company for the treatment of HIV/AIDS. And of course, the famous case of hydroxychloroquine, the drug which is largely manufactured in India, which is an unpatented medication, which was seen as a potential treatment when it was repurposed for the use to treat COVID-19. So there were some issues of patents and remdesivir, which I'll perhaps turn to in my next slides. Of course, now the debate is focusing more on the vaccines, the Oxford AstraZeneca vaccine, Pfizer-BioNTech, and Moderna. Now, one of the themes of my talk today is that what do we do about the fact that all these vaccines were initially publicly funded? It was taxpayers' money that paid for this. So is it in the public interest for IP rights to be granted to AstraZeneca, to Pfizer, and to Moderna to manufacture and supply products which were essentially invented through publicly funded research? So that's one of the themes that I think we should highlight today. The other theme is, of course, the one which India and South Africa have already raised. The fact that this is not just about the patents, it's about the regulatory test data. If you want to get the Medicines Agency to approve a vaccine, you need to have the information about the test data, which would have come from, in these cases, AstraZeneca, Pfizer, or Moderna, and you need the trade secrets and the know-how about how to manufacture and store these complex technologies. Now, I've mentioned compulsory licensing. So to what extent did compulsory licensing help in the COVID-19 IP response? Well, in April last year, Israel issued a compulsory license so that the patented medicine for treating HIV, Kaletra, could be repurposed for the treatment of COVID-19. The patent owner, the American company AbbVie, formerly known as Abbott Pharmaceuticals, faced with this compulsory license, which was actually issued in Israel, then announced that it would not enforce its patent rights in any country where those patent rights still existed. However, the reality was that Kaletra is quite an old drug and was going to come off patent quite soon. The patent was going to expire and had done so already in many countries. And sadly, it proved not to be such an effective treatment for COVID-19 in the final instance. Only 2 days ago, the Latin American state of Bolivia announced that it was going to go further than Israel, that it was going to use the mechanism which I've just described to waive a particular compulsory licensing provision under Article 31, paragraph F of the TRIPS agreement, and that Bolivia has notified the World Trade Organization as of the 12th of May of this year that it will ask some of the 50 countries around the world which are capable of making and exporting vaccines to it, that it will ask those countries, or at least some of them, to issue compulsory licensing in the exporting country and to send COVID-19 vaccines to Bolivia to deal with the pandemic in that country. So this will take away temporarily the normal expectation of the vaccine manufacturers and owners of the patents to make commercial profit from those inventions. So the COVID-19 pandemic really is not just a repeat of the Access to Medicines campaign that I've just described to you, which was really focusing on the safeguards, the flexibilities in the TRIPS agreement, which were highlighted in the DoHA Declaration. And 1.5 years later led to this temporary waiver to allow compulsory licenses to be issued for export. And only in January 2017 became a permanent amendment to the TRIPS agreement. We're not only talking about something which can be dealt with in a case-by-case basis by compulsory licensing. Now let me move on to some of the complexities about who owns the IP and how these vaccines are actually being manufactured in the current pandemic situation. You'll see the quote on the slide to accompany the picture of Professor Adrian Hill, who leads the Jenner Institute at Oxford University, that at the time that Oxford invented this vector process for delivering the vaccine, that Professor Adrian Hill stated to the New York Times that personally, I don't believe that in a time of pandemic, there should be exclusive licenses. And Professor Hill went on to say, so we're asking a lot of them, by which he meant the industry partners. Nobody is going to make a lot of money off this. Well, how wrong this statement proved to be. Only days after Professor Adrian Hill made that statement to the New York Times, the AstraZeneca website issued a press release announcing a landmark agreement between AstraZeneca and Oxford University, which would be a collaboration for the global development, manufacturing, and distribution of the so-called Oxford vaccine. In an article in the Wall Street Journal, another academic from Oxford University, Professor John Bell, gave an insight into some of the behind-the-scenes arguments which had taken place at Oxford University. I will show you now a quote from Professor Hill's interview with the Wall Street Journal. Unlike Professor Adrian Hill, Professor John Bell, who is a more senior academic in the management of Oxford University, said the following: people are going to come back and say, oh my God, another British university inventing something worth a ton of money. And guess what? They gave it away for free. So for the management of Oxford University, there was a real imperative to commercialize this invention and to potentially make money from it. Now, the negotiations which led to the granting of an exclusive license to AstraZeneca were complex because of the different institutions which were involved. So the patents on the Oxford vaccine are still owned by Oxford University. The patent applications were filed by Oxford University Innovation and are being commercialized by a spin-off called Oxford Sciences Innovation. However, the scientists at the Jenner Institute, particularly Professor Sarah Gilbert and Professor Adrian Hill, are also directors of another company called Vaccitech. And this is also involves the head of global financial trading from Deutsche Bank, the former head of global trading at Deutsche Bank. So there were discussions about who owns the vaccine, who should be entitled to sign the licensing agreement to allow AstraZeneca to manufacture and distribute this. Now, the first choice of Oxford University was an American pharmaceutical company called Merck. However, the UK government got involved, and the Department of Business expressed concerns that an American company, if it was granted the exclusive license to this product, might not deliver the vaccines as the pandemic took hold. There were also negotiations between Oxford University because the academics wanted this vaccine to be sold at cost, so that the country which would get the exclusive license would only have a sell at a price which would cover the manufacturing costs without making profit. And in fact, today, the Oxford AstraZeneca vaccine is the only one of the vaccines which is being sold not at profit. For example, in the European Union, the Oxford AstraZeneca vaccine is being sold to the EU at €2 a shot. Of course, you have to give 2 doses to each person, so that's €4. Whereas things like the Pfizer vaccine or the Moderna vaccine are being sold at something between 10 or 12 euros per shot. So either 20 or 24 euros per person. So they've achieved something in terms of manufacturing and supplying at cost, at least, AstraZeneca says, while there is a global pandemic. If there are booster shots afterwards, we expect those prices to increase after the pandemic status has been removed by the WHO. Now, let me return to this issue of why it was that the UK government was pushing Oxford University towards AstraZeneca instead of the American company Merck. Merck was very experienced at manufacturing vaccines, AstraZeneca less so, a less experienced vaccine manufacturer. Well, despite the relative inexperience of AstraZeneca in manufacturing vaccines, the fact was that the UK government last year was extremely concerned that US President Donald Trump would engage in vaccine nationalism, that if the products were manufactured by Merck in the United States, at some point, the US president would stop these vaccines being exported out of the US. And you'll be familiar with the term today, which is this of vaccine nationalism. And in fact, this concern of the UK government was proved to be correct when on the 8th of December, an executive order was issued by the US president stating that any vaccines manufactured inside the US should be used primarily for American citizens, that the US citizens should have priority access. So maybe this was a good judgment call by the UK government to award the contract to the less experienced AstraZeneca. So as I've already mentioned, the announcement which came last year was that this tie-up between Oxford University and AstraZeneca would mean that vaccines would be manufactured at no profit. And this was like an altruistic gesture to deal with a global pandemic. This is my vaccine card. You can see that I've had my first dose of the AstraZeneca vaccine. I had it on the 26th of March of this year, and that this is my official vaccine card from Public Health England. You'll see that, of course, the medical advice is that the second dose should come after 12 weeks, when I expect to have my second jab of the AZ vaccine. Now, the interesting thing about this is that because I'm an academic and a bit geeky, I did an internet search, just using the Google search engine, And I just typed in that batch number, no other information. I just typed the batch number. And this is what I found. It was the top hit from the search engine. It's from the UK Medicines and Healthcare Products Regulatory Agency. And as you understand already, a vaccine needs to go through clinical trials to show that it's safe and manufactured to high quality before it's distributed to the public. Now, the AstraZeneca has two large manufacturing centers in the UK where it makes the vaccines. So you would expect that my vaccine had been manufactured in the UK by AstraZeneca. But when you look at the second paragraph of this announcement by the UK Medicines Agency, you will see that the third batch number in that list, where it says for these purposes, the authorization of the AstraZeneca vaccine, the batch numbers listed manufactured by the Serum Institute of India are to be treated as if they were COVID-19 vaccines of AstraZeneca. So this really, was a shock to me that at a time when India itself is in need of vaccines, that the SSI was actually exporting these to the UK, and that this was being administered to the British public. But of course, it wasn't a surprise that there is this tie-up between the Serum Institute of India and Oxford and AstraZeneca. This was announced way back in April of last year. But the primary purpose of this tie-up was, of course, to allow, first of all, the manufacturer of the Covishield, the Indian version of the AstraZeneca vaccine, to be manufactured under license for domestic supply in India. And also, crucially, that the SSI would be supplying Covishield to COVAX, the World Health Organization mechanism for manufacturing and supply of vaccines to countries which can't afford to buy at the kind of market rate. So for me, this raises a number of questions which I think are still relevant when we come to look at how the waiver of IP for vaccines and related products might be applied at the end of negotiations at the WTO. I was interviewed by Fortune magazine in August of last year, and here is a quote from the article here. What's perhaps surprising is that given that it was the British government who paid for the research which was conducted at Oxford University in the first place, why aren't governments and vaccine manufacturers more open about these relationships? Why don't we know what's in the deal which was signed between Oxford and AstraZeneca to provide an exclusive license for the IP? And why don't we know what is in the agreement between AstraZeneca and the Serum Institute of India? Again, because this is publicly funded research. In a similar argument, I published an article in a magazine last September in which I pointed out that it's really vast amounts of public money that are contributing to the investment. So this isn't the typical situation whereby we need private IP rights, including patents, to incentivize companies to do the research. That's the classical utilitarian argument for granting patents. Creates a reward system. But this is publicly funded research. The governments and the taxpayers have already paid for this. So we really need to rebuild public confidence about who owns the IP and how that IP is being licensed and controlled in a way which ensures equitable access. So really the takeaway points, as I've indicated, IP is part of the problem. IP in terms of patent rights and the related rights about know-how, trade secrets, and clinical trials, regulatory data can create barriers to manufacture in the COVID-19 response of vaccines. But IP, of course, can also be part of the solution in a more typical problem situation of companies wanting to have the incentive to invent and perhaps in future improve as the variants for COVID-19 start to emerge even more. Nevertheless, the global response to COVID-19 has in many ways been positive. You know, the speed in which these vaccines have been produced has been unprecedented, and it's been as a result of collaboration between governments, providing a lot of the money, of private companies working with governments and universities, and with companies working together, sharing information in new and unprecedented ways. So that's a positive message to take away. And as I've also indicated, probably unlike the HIV/AIDS pandemic 20 years ago, where compulsory licenses were seen to be the possible solution, the complexity of the issues that I've just described today mean that really we need a more sophisticated solution than just using the existing compulsory licensing mechanisms available in the TRIPS agreement. We need to involve medicines agencies. We need public-private partnerships between governments and private companies. And we need to know who owns the IP when these systems are set up. So sort of takeaway messages from my brief talk today. I've explained that since the inception of the TRIPS agreement in the 1990s, there were always inbuilt flexibilities and safeguards. During the HIV pandemic, most of this attention was on how compulsory licenses could be used to temporarily set aside the patent rights of pharmaceutical manufacturing companies. But we really are with the complex technologies involved in both the adenovirus and the mRNA vaccines today. You need access to the know-how, not just the information disclosed in a patent document. Also, I've expressed some concern about the lack of transparency in the licensing agreements, using the example of Oxford University in its deal with AstraZeneca. And there are so many uncertainties about who owns the IP and how it is shared that even if there was a waiver as a result of the India, South Africa, or US initiative, with things which are unregistered IP rights, like the know-how and trade secrets, it's difficult to know how you would get access to the information because by its very nature, it's undisclosed confidential information. So how do we know what the manufacturing techniques are, for example? So all these manufacturing, storage, and supply chain issues are really underpinned by these barriers about accessing non-patent intellectual property. So the COVID-19 pandemic raises a number of complex problems. It requires coordinated responses, and the IP policies that I've been describing today are of course part of the bigger picture, but they're an essential component of addressing effectively the current pandemic crisis that we face. So thank you very much for listening. That's the end of my talk. So I will now hand back to my colleagues.
Thank you, Duncan. That was very, very insightful. I am sure that we have learned a lot, and this is very, very complex, to be honest, and definitely takes quite a lot of understanding of this, how the nitty-gritties involved in this particular sector. So we have had a great response on our YouTube Live, and we've had students share some questions. Now, one of the questions that they have shared, they're more generalized towards intellectual property. And students would like to know what is the difference between the intellectual property in India and intellectual property in UK? So if you could just let us know if there are any basic or something that stands out particularly.
Okay, so what are the main differences between intellectual property in India and in the UK. Well, I'll restrict my answers specifically to patent law, since this was really the topic of my talk today. Of course, in 1949, India inherited the old UK patent law, the British Patent Act. And what happened in 1970 in India was that the parliamentary inquiry in India, the Iyengar report, really focused on the fact that most of the patents which are owned in India were owned by British companies or from other European or US multinationals. So it was really a recognition that the Indian citizens were really carrying the burden of high prices, which were due to foreign-owned IP patents. So, strategically, India did something quite clever in 1970 when it amended its Patent Act by making it a much more pro-Indian citizen in the public interest. Now, the TRIPS agreement, which I've been talking about, explicitly allows international IP obligations to be applied in national law in a way which meets local needs and the public interest. So there are differences in particularly the ones that I outlined, and also in the Indian Patent Office, the way that it examines patents and decides. Many of your students will be aware of the phrase evergreening, that often the multinationals will try and get another patent on the same drug. And in 2013, we had a very high profile case in the Supreme Court in India, where the Swiss company Novartis lost the case, and the drug was found just to be a new formulation of a known cancer drug. So the Indian legislature and the Indian judiciary have been very proactive in acting in the public interest. So my my concluding remark would be, this is really, the international IP system is designed to allow this. And India has been in many ways, a model example of how you can apply the law in a different way in the national interest. So thank you for the question about the key differences between the UK and India.
Thank you, Duncan. Another question is that, are IP rights required to get licensed separately in separate countries? Is there a condition regarding the universal applicability of the IP?
Yeah, okay, I can answer this. So, yes, is licensing required on a national basis? So the first point is that IP rights are rights which are granted in each jurisdiction. So as the students will be aware, you have to apply for and be granted a patent in every country in which you want that patent to be valid and in force. And you then have to go before the national courts of each territory to enforce those patent rights separately. So the existence of the rights is in national law. Then we return to the issue of the licensing agreements. And there we can see that it is possible to have licensing with international reach. So I mentioned earlier one of the treatments for Covid-19, remdesivir, and actually the American company which owns the patents in different countries, an American company called Gilead, they signed a licensing agreement with a lot of drug manufacturers in India and Pakistan and Egypt to allow them to manufacture a cheap version, generic version, and to export to different markets around the world. So in that respect, that's an example of how the licensing agreement can include different manufacturers in different countries and allow distribution on a wider scale as well. So that's how I differentiate between the granting of the rights and the licensing, which is on a more international scale.
Great. Jaspreet, one of the questions is that if students are interested in applying for an LLM in intellectual property rights, how can they approach or how can they apply? If you could just tell us about entry requirements, etc.
I'm going to leave that to my colleagues because I'm a mere academic, and the complexities of university admission system is not something that I'm at all competent to comment on. But the general comment that I would make is that we have, I suppose what distinguishes our program is that we have such an international cohort of students. So my students from India are really top quality. And they're mixing with students from Brazil, from different European countries, from Southeast Asia, from China. And often the students say, actually, that international network, when they become our alumni, is one of the most valuable things together with the education, that when they're working as practitioners, they ever need to have an IP lawyer in Colombia, in Latin America, because their client in India has got an issue with Colombian IP law, they know somebody because they know the top lawyers because they were all studying together. So the community of scholarship is a really important factor.
Definitely. Jaspreet, over to you. If you could just mention a little bit about the admission process, how students can apply to Queen Mary for LLM.
Yeah, it's very simple. Thanks, Mishi, for that. The application process for applying to Queen Mary is very simple. So they can choose the specialization or the program that they're looking forward for the LLM, and apply through our website with simple documents or with the help of our colleagues in SIUK, where they can give them the assistance as well. So they will need to submit one reference letter, personal statement, and obviously all their academic documents along with their CV to make an application. With regard to the entry requirement, it would vary definitely depending on the university that they're coming from, but roughly about first-class degree is what we would look for most of the universities.
Thanks, Jaspreet. Another question on the same lines is regarding IELTS. Can we provide exemption towards IELTS?
To be honest, right now, I would kind of recommend to take the English language test if possible, because the UKVI regulations actually put that as one of the major pointers that is there for the point system basis that they have introduced. But there are a few exceptions that we can accept IELTS waivers as well.
Great, thank you. Now, Duncan, you meet a lot of students, and they understand how do they manage their time between studying and if they're doing any extracurricular activities or even working part-time. If you could just tell us a bit more about the student life, or observed is the best practice for students when they are studying.
Given that London is one of the most vibrant and exciting cities in the world, it's certainly a great temptation to do a number of other things while studying in the UK, and that is a very important part of the student life as well. The opportunity to live in the centre of London, because of course Queen Mary is the only college in London which has a dedicated student village and a campus. So we're the only campus university in the centre of London. So otherwise it can be quite isolating in such a big city if you're just renting an apartment. But the fact that we have this student community of thousands of international students really, I think, is what is a distinctive factor. In terms of extracurricular legal activities, we know that many of the students who come from our master's program are particularly attracted by the fact that we have a legal clinic, which is called Q Legal, in which the students work pro bono to provide advice, for example, in this field of intellectual property, to inventors who are not sure how to protect their IP on their inventions. And the students are working with top law firms and partners in law firms who provide pro bono services. And that really means that by the time the students finish their legal education at Queen Mary, they not only have the academic qualification of a master's degree, but they have the practical experience on their CV that they have worked with top law firms and have provided practical legal advice in real life cases.
Great. I mean, there are umbrella of services for students to definitely kickstart their career and use it to their advantage at Queen Mary. And we are very proud of supporting the students all throughout. One of the questions that has come from Ayush Kalra, who's one of our viewers on YouTube, he's asked if you could let him know about how to approach transferring a license internationally or how to get a license internationally. I mean, I know it is a very vast topic, but if you could just give him some tips.
I'm afraid I don't provide free legal advice, but he's very welcome to contact Q Legal for pro bono.
That's a good one. Thank you so much. And I think this marks the end of the session. And thank you so much, everyone, for joining in today. And over to you, SIUK, and a special thanks to our faculty at Manipal University, Jaspreet, Hamid, and Duncan as well. Thank you.
Thank you.
Thank you so much. Well, that was a great session, and you really connected really well with the students. So thanks a lot for putting together all the key points, providing expert guidance to interested Indian students. And I'm positive that this session will be of great help to all our students, and we'll look forward to more such interaction and engagement with the QMUL and SIUK India. So thank you so much, and thank you all the faculties from Manipal University for joining us today, and thank you, QMUL.
Thank you.
Thank you. Bye.